Divorce in England and Wales is simpler than ever, but myths still persist. Let's separate fact from fiction. I'm Victoria Cannon, partner and head of family law at Hugh James. In this video, we're tackling the most common misconceptions about divorce. What's true, what's outdated, and what could trip you up. Whether you're considering divorce or advising someone who is, clearing up these myths could save you time, stress, and money. Myth 1. We've been separated for years, so everything's already split. It's a common assumption, but the law doesn't work that way. Unless there's a formal financial order in place, claims can still be made. Myth 2. If everything's in my name, it's mine. False. The court looks at the whole picture. It doesn't matter whose name is on the paperwork. If it's a matrimonial asset, it's on the table. Myth 3. Adultery gives me an advantage. Since 2022, England and Wales operate under a no-fault divorce. That means the reason for the split won't affect who gets what. Myth 4. We agreed it between ourselves, no need for legal advice. Verbal or formal agreements don't protect you. Without a formal court order, your financial ties remain, and that could cause problems later. Myth 5. Prenups aren't worth the paper they're written on. Not true. While not legally binding, courts increasingly uphold prenups that are fair and properly drafted. They're a smart move for many couples. Let me share a real-life example where a common myth could have led to a costly mistake. A client came to us ahead of his second marriage. He divorced his first wife many years ago and was now asking for a copy of his final order, what used to be called the decree absolute. During the call, I asked whether financial settlement had ever been formally agreed during his first divorce. He told me no. They'd had a verbal agreement at this time and he assumed the final order meant everything was dealt with. I explained that this wasn't the case. The decree absolute ends the marriage, but it doesn't sever financial ties. That means his ex-wife could still make a financial claim against him even years later. With his first wedding fast approaching, and his fiancée rightly keen to avoid any loose ends, we moved quickly. We arranged a clean break order, which legally cut all financial ties with his ex-spouse and protected him from any future claims. Only once that was in place was he free to remarry with peace of mind. And of course, I wouldn't be a good family lawyer if I didn't also advise him to consider a prenuptial agreement this time around. Understanding your rights is crucial, but so is acting on them. For confidential legal advice tailored to your situation, contact the family team at Hugh James.